There we are. Good. All right. All right, and then we have on the Zoom, we have Dr. John Black, who testified last time, and Mr. Robert Willis, who will be testifying today. And this case is being live streamed on Decast at the Supreme Court website. And I want to record this. Did you take it back? I wanted to record it also. Not that there aren't any. Well, in the meantime, there were a couple of additional motions filed. And I did, I'll make a record. About, 6:02 this morning, a call came into the clerk, to which I have not listened, from a person whom the clerk advised me claims to be a witness. And we called IT, and they made copies of what was recorded, and it has been sent, I think, to both sides. So, and I haven't listened to it, and I just spoke with each of you, and I asked both, should I listen to it, and I was told by both it wasn't necessary. So that's where I'm going to leave it, unless directed otherwise. I think, yeah, no, here, I'll use this. Thank you. In the meantime, why don't we take up this motion for a protective order regarding Officer Franco? Is the motion opposed?
It is.
Okay. Mr. Binger?
Your Honor, I filed this motion regarding one of the witnesses that's been listed by the defense, Amanda Franco. The basis for this motion is that the officer here has virtually no connection to the case. The officer encountered the defendant on the evening of this incident, had a couple of very brief and cordial conversations with him because she had recognized him from the incident from June of last year, which was the subject of our other acts motion. And the court has already ruled on that motion. The court has already ruled that the state is not going to be allowed to introduce evidence regarding that incident. And just to refresh the court's memory, that was an incident in which there's an allegation that the defendant's sister was involved in a one-on-one fight with another female. And during that fight, the defendant intervened on behalf of his sister, essentially turning it into a two-on-one fight. And I argued that it went to the issue of self-defense because the defendant was purportedly trying to assist his sister, but a two-on-one fight is hardly appropriate. This was recorded by some other individuals, and that video was submitted to the court as part of the motion. It's my understanding that after that video ended, there were subsequent interactions between the defendant and the individuals who made that video.
You know, we did go through this before.
Correct.
So get to the heart of your motion.
Certainly.
Please.
The heart of my motion, Your Honor, is that the court has already ruled that that incident is not going to be introduced into evidence at the trial. The defense, by calling Officer Franco, I believe, would be seeking to relitigate that prior incident because, as I said, her only connection to this case is the fact that she recognized the defendant from taking a statement from him regarding that prior incident. And since the court has already excluded it as part of the state's case, I believe it's only fair that it be excluded as part of the defense case.
Thank you. Mr. Sharofsky.
Judge, I would never relitigate a motion that I've won. So I understand, having been a lawyer for a little bit, that if I open a door or I do something that would potentially bring something up that the court has already precluded, I guess I do that at my own risk. That's not the goal. I would never do that. It makes no sense based on what Mr. Bringer has told you today that I would ever try to do that. But she is a witness. She was present during the incident. So if we believe, I've never had this before, where we believe that she may have relevant information as somebody that was present at the scene, that she be preemptory barred from testifying because they think that we're opening a door that I have no intention of opening. So I think it's only reasonable that the court allow her to testify if she has relevant information under 90401. And if it is, then she'd be allowed to testify about that. I have no interest in bringing up to relitigate something that has already been ruled in our favor.
Thank you. The motion actually seems to encompass not just the incident of July 1st, but also contact that allegedly was had between the accused and Officer Franco on the 25th of August. So I assume that if you wanted to get the evidence in on your initially as evidence of other crimes, wrongs, and acts, and I ruled against you, but if the defense wants to go into it, then you probably get your way and it'll come in. With respect to the incident that allegedly occurred on the night that the shootings took place, then what is the reason that you think that I should suppress that?
Because it has no relevance. The report that Officer Franco submitted regarding her interactions with the defendant is very brief and simply says she had 2 brief but cordial interactions with the defendant after recognizing him from that prior report or from that prior incident. She would not have known him otherwise. She, I'm sure, was out on the streets that night encountering probably dozens, if not hundreds of people, some of whom she might have recognized, some of whom she'd probably never seen before. She only interacted with the defendant because she recognized him from that prior report. Otherwise, I doubt she would have had any interaction whatsoever. So I don't know what the relevance of this is, and I guess if the defense wants to introduce this evidence, I would ask that there be some sort of offer of proof as to what the relevancy is of it.
This is what. I apologize, everybody. What do you want for $50,000, right? Anyway.
Judge, he's charged with reckless. He's charged with multiple counts of reckless behavior, right? And so when you are listening to the evidence and the jury is making a determination as to whether or not that conduct is reckless, all the facts and circumstances for the jury instruction come into play. What he was doing, how he was doing it, how dangerous it was, the recognition of that danger, and him having contact with police officers that evening, them assessing that behavior, allowing him to move on with his night, certainly is relevant to his state of mind as it goes to whether or not that behavior was in fact reckless, as that is defined by the jury instruction. So it's relevant. And if it's not, Mr. Bringer can ask that it be stricken. You can take him up on that. But his contact and Mr. Rittenhouse's contact and what he's doing with law enforcement and the contacts he has with them, under the idea of whether that behavior is reckless or not, all of those contacts are relevant under the jury instruction. Simple as that.
I think I don't see any reason to anticipate trouble. I can understand that you might be apprehensive as to some misuse of some kind of testimony along this line, although I'm certainly not suggesting that I see misuse coming, but so you can contemporaneously object. I think that's probably the better way to handle it rather than for me to slam the door on them before even hearing what purpose they want to use it for.
Your Honor, this does tie into the motions in limine that I filed, and I appreciate Attorney Traucy making explicit what I have long suspected, which is that this is going to be a trial over the police department's activities that night. The argument here that was just put on the record is that the police saw the defendant that night, didn't stop him, and so therefore there's some culpability on their part, or some sort of implicit approval of his activities that night, or express approval of his activities that night. That's not relevant, Your Honor. The police assessment of the defendant prior to him killing two people does not have any bearing on whether or not his actions in shooting and killing two people were lawful or reckless or not. The jury is the one who's going to make the ultimate determination there. And whether or not police officers saw him earlier in the evening when he wasn't shooting and killing people, and whether or not they stopped him or didn't stop him or said anything to him or didn't say anything to him is not relevant to the ultimate decision in this case. But I think the defense argument here is pretty clear. They want to say that because police officers saw him and didn't stop him, somehow that makes him lawful, that makes him justified. And I don't think that's the case because, number one, that's not the determination here as a matter of law. But number two, the officers didn't see him shooting people. They didn't see him killing people. They saw him at a time in the evening when he was on private property guarding a building, a business. And that's different than the activities that are alleged to be reckless here. So I don't think there can be a connection here between what the officers may or may not have done earlier in the evening and whether or not the defendant's ultimate actions in shooting and killing two people were intentional or reckless or justified. So I think this is exactly where I thought that the defense would be going. It's one of the subjects of one of my motions in limine, Your Honor. It's, I believe, motion number 3, and it seeks to make sure.
Number 4.
I'm sorry, I've got it misnumbered. It's number 4, and that's part of my motion in limine here, which is that the defense should not be allowed to, actually, no, it's not number 4. It's number 5, actually. It's the motion in limine talks about whether or not anonymous law enforcement officers made statements earlier in the evening regarding the defendant's activities, or whether or not they talked about their plans in terms of crowd control or things like that. And this is not a trial about the police activities. It's not a trial about police tactics. It's not a trial about whether or not law enforcement that night took action or didn't take action. This is a case about what the defendant did that night. And I'm concerned that this is going to be turned into a trial over what law enforcement should or shouldn't have done that night. And I don't think that's what this court or what this trial should be deciding.
Oh, are we arguing the motions in limine now?
We are.
Okay, very well. So no, I guess we're just doing number 5 right now. Oh, I don't need it for this one. So
yeah, he says 4, you say 5. It's like Protestant versus Catholic with the 10 Commandments.
So this is my understanding. So in the video, there is a statement by a police officer who says, an unidentified police officer saying, we appreciate you guys, we really do. Now, what Mr. Binger initially said is, that's hearsay. Now, we are obviously not offering it for the truth of the matter.
It's not hearsay. I would say right now, it is not.
It is not.
It is not hearsay. I
Correct.
don't want to spend a lot of time. We can discuss it again at the trial, but just to save time this afternoon, it's not hearsay.
I agree. So, and what I've laid out for the court, and I just want the state to understand this, that no one is saying that because the police, however they reacted, that Mr. Rittenhouse was lawful and justified. That is not a defense to a charge. But Mr. Binger has chosen to charge reckless conduct. Okay? He's made that decision. Now, he has to be able to show the defendant's conduct showed an utter disregard for human life. All I've done is looked at the jury instruction on what a fact finder is supposed to consider when making that determination, Your Honor. And if you look at that instruction, they are to consider what the defendant was doing, why he was engaged in that conduct, how dangerous that conduct was, how obvious the danger was, whether the conduct shows disregard for life, and all other facts and circumstances related to that conduct. And I would submit to you conversations, interactions that he has with law enforcement go to his state of mind as to whether or not, A, how obvious that danger was, and whether it was actually dangerous conduct. Those are relevant factors to determine reckless behavior. And when he has conversations with police officers and they let him go about his business, and when the police say things like they've said on that tape, those go to his state of mind. They are absolutely relevant for the charge of reckless. He is charged with 3 different counts of reckless behavior in this case. So the way that Mr. Binger has chosen to charge the case has opened up, in our view, has opened up the facts and circumstances surrounding what had happened, because the totality of the circumstances go into play in determining whether or not behavior is shows an utter disregard for human life. And that's what we're saying it was.
Now, the reason I said it isn't hearsay, and I don't want to get an extensive discussion about it, and we can do it at the time of the trial, but hearsay is evidence offered to prove the truth of the matter asserted, and there is also an exception for plan or present intent. I don't want to get too deeply into this, but you denounced it as irrelevant hearsay. The relevance is open to question, but I don't think it's hearsay because it's not being proved. At least I would not permit it to be used to prove that the entire police presence on that evening appreciated Mr. Rittenhouse's behavior or his presence or whatever. So I don't think it's hearsay, and I don't want to get bogged down on that. Relevance is another matter, but he's addressed that. Do you want to respond to that?
I do. This would be akin to a police officer telling Mr. Rittenhouse at 1 p.m. that he stopped at a stop sign properly, and that's used as evidence to show that at 10 p.m. When he shoots and kills people that somehow he's not reckless. They're remote in time, they're remote in behavior, they have no bearing on one another whatsoever. The evidence with regard to these statements by anonymous law enforcement officers occurred earlier in the evening at a separate location with regard to separate behavior. And no one is going to argue in this case that the defendant was reckless or unjustified in desiring to protect private property, remaining at a private business location, and trying to secure that location. That is something that countless people in Kenosha did that night and many nights around that time period, whether it was their own home or their business or their neighborhood, and they are well within their rights to do so. The activities that we're talking about in this trial did not occur at that location. They did not occur on private property. They did not occur in the course of protecting that business. They occurred blocks away, far away from the location that Mr. Rittenhouse took it upon himself to guard that night, when he's out wandering on his own without any members of his group nearby, and he is getting himself involved in things that are well beyond his purview. This occurred, these shootings that we're going to talk about at this trial occurred well beyond the police lines, outside of the view of the police.
But what was the law in Kenosha south of 60th Street on that night? Because when you were here last time, you were talking about the police zone, that the police had pushed people back, presumably to protect the public buildings in this area. But what was the status of law enforcement south of that? I mean, or down 60th Street, where there was enormous amount of looting and arson. What was the state of law in those areas?
There wasn't much. Absolutely. I agree, Your Honor. The police had made a decision that night that their resources would not allow them to get into this area and try and arrest every criminal, stop every crime, take care of it.
I'm talking about arson.
Your Honor, to be honest, the arson that night, the primary arson in this time period occurred on the nights before. On this particular night, there's very little arson. There's a dumpster, there is a trailer that's dragged out in the road. Over on 60th, I think what you're referring to is over about 15th or 16th and 60th, right before the embankment, there's a car dealership, and I think the owners of the car dealership actually piled a bunch of tires in the middle of their parking lot and set them on fire for some reason. Didn't damage any cars or anything like that. The arson that affected CarSource, for example, the lot across the street occurred on one of the prior nights. The Department of Probation and Parole building occurred on one of the prior nights. So on this particular night, arson of large property is really not going on. There's a couple of minor, like I said, a dumpster fire and a trailer and things like that. And by and large...
Who knows how that evening is going to develop?
These events occurred at about 11:45, 11:49 at night. So this is several hours into the evening. The crowd at this point there's clearly some property damage going on, particularly at the 63rd Street CarSource location. There are individuals that are using clubs and metal bars to smash out car windows. Doesn't appear to be any arson going on, but there's certainly some property damage going on down there. And to your point, Your Honor, the larger question you're asking is, was this a situation in which the law enforcement were going to come in there and arrest people for smashing car windows or things like that? And no, I don't believe that's the case. So that is true. But again, the evidence that's being sought to be introduced here, Your Honor, is from a different time, a different location with regard to different behavior. And the only possible relevance this could have is to try and convince the jury that those statements gave the defendant the state of mind that he was then justified to wander off that location, intervene in other behavior, confront unarmed individuals, and shoot and kill them. And again, like I said in my example, that would be like the police telling somebody several hours earlier that you stopped properly at a stop sign. It has no bearing. It has no relevance to what's going on. The argument that they want to make, and I understand the court's ruling on hearsay, but this is sort of backdoor hearsay, Your Honor. What's really going on here is it's under the color of, we want this jury to believe that the law enforcement officers approved of what was going on that night. We're not going to introduce it purportedly for the truth of the matter asserted, but it's going to come in and the jury is going to be under the guise that this is being approved by law enforcement. And that's not at all the case here. There is no evidence that any law enforcement agency approved of what the defendant was doing when he left 59th Street CarSource, when he started wandering the streets with a gun, when he's out after curfew on public property, when he's carrying a gun illegally, when he's getting involved with unarmed individuals, intervening in their property, and then eventually shooting and killing them. There's no law enforcement approval of that. There's no law enforcement involvement in that whatsoever. It is completely separated in time, in location, and in the quality of the incident and the type of behavior involved. So for those reasons, Your Honor, this has no relevance to the issues at the court. And I think it does run the risk of undue prejudice here and confusion of the issues, because the jury could conclude that, well, if the police saw him and they thought he was doing everything okay, then this shooting is justified. And as the court has acknowledged, that is not the issue here. That is not something the jury can conclude in this case. They have to make their decision based on the facts and the law, not on whether the police may or may not have given their stamp of approval on any sort of behavior here. So I think it runs the risk of undue prejudice, of confusion, and frankly, I think it takes some of the ultimate decisions out of the jury's hands. The jury is the one who needs to make this decision. And giving the color of some sort of law enforcement approval here, I think interferes in that process impermissibly.
Well, I agree with your concern about the suggestion of some sort of an imprimatur from the police as to the defendant's behavior. Of course, the defendant's behavior at the time that the police allegedly saw him was different from his behavior at the time of the incidents. But I think the defense makes a very good point that I'm going to be telling the jury about things they are to consider on the reckless conduct charges, and they're specifically told, consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether well, it goes on. But the point is, if the jury is being told, I think the defense point is that if the police, if the defendant is walking down the sidewalk or the street and doing what he claims he was hired to do, and the police tell him it's a good thing you people are here in the given the state of lawlessness that's existing, is that something that's influencing the defendant and emboldening him in his behavior? That's the issue I think that they're suggesting, which would seem to me to be an argument for relevance.
Your Honor, I think it's important to clarify that this was not a situation in which the defendant was walking down the street when he encountered the police. You have clarified something that I think is important to keep in mind, which is that the police had established a line at 60th and Sheridan and had moved all of the individuals from the streets south of that line. When the interactions that we're talking about between the defendant and law enforcement occurred, it was while the police were passing by the 59th Street car source down to 60th to establish this line. Once they passed the 59th Street car source, there are no viable threats to that location anymore. All of the individuals from the street have been moved out of that location. At that point, the 59th Street car source is essentially behind police lines. It is in a zone of relative safety at that point.
Now, for some reason, I formed the impression, perhaps incorrect, and of course I don't have nearly the wealth of information that you people have, but I formed the impression that the car source north of 60th Street had a common ownership with the one at 63rd Street?
That's correct. There are 3 car source lots. One is on the east side and in the 5800 block of Sheridan, one is on the west side in the 5900 block, and then there's the one down at 63rd where the eventual first shooting occurs. The defendant and his group of compadres are at the 59th Street location. They spend almost the entire evening at that location. They have taken it upon themselves to guard that physical location, and as I said, when these...
I'd like to... Are we going to find out, and I don't want to be injecting things, you say they have taken it upon themselves. Was this something that was done out of the charity of their hearts, or were they being employed to do this?
They were not being employed. They were not paid. They were not hired. They're not licensed security guards.
Judge, we have photographs of all of those gentlemen with the owner of the car source taking photos that night together. 2 of the people had worked at car source previously. They had been given entrance into the building and ladders to go up on the roof that evening. So the idea that they had commandeered this building, that is not what the evidence in this case is going to bear out at all.
And that's not what I said. What I said is they were not hired to do this. Now, there were communications with the owner of this particular location where there was some sort of understanding as to what their responsibilities were going to be. But my point is, Your Honor, the larger point here is that when the police statements that we're talking about that you've ruled are not hearsay occur, they occur as the police Bearcats are moving past 59th Street car source and establishing that line at 60th. So at that point, the 59th Street location is essentially behind police lines. It is now no longer in any sort of danger at this point. What happens after that, after some time, is the defendant then leaves that location on foot and winds up south of 60th on his own. That's when the shootings occur. So when I said earlier there's a distinction in terms of the amount of time and the location and the behavior, that's what I'm talking about. He crosses the police lines south of 60th. He goes out into crowds by himself with no backup, and eventually winds up 4 blocks south at 63rd Street, where he engages with Mr. Rosenbaum.
Well, regardless of where he was and what the state of law enforcement of any kind it was at that time, I'm not sure are really critical questions. The question is whether the defendant, whether the statements or statement that the defense is interested in presenting is something that would bear on the mind of the defendant, which is what we're looking for on all these charges, what the state of mind of the accused was. And I will tell the jury, as we always do, you can't look into a person's mind to find out his intent, but you're to consider what he was doing, why he was doing it, among other things. And I don't know. It seems to me my bias at this point would be towards allowing that evidence in, but I'm like so many other things. As you know, you've tried cases in here. I'm the one who always wants to hold back until I see the whole field of evidence, because I just hate being up here after making a ruling and saying something will or won't come in, and everyone's planning on that, and then suddenly say, whoops, I just changed my mind. So I don't want to do that. So I give you, in many instances, what I'm thinking about as far as part of what's going to be the ruling. And I would tell you at this point, I would think that that probably is admissible in this case.
Understood. Thank you.
Okay. So then, let's see. We might as well start as long as we're on that motion with the reference to you're asking that the defense be prohibited from referring to Joseph Rosenbaum, Anthony Huber, or Gaige Grosskreutz as rioters, looters, or arsonists, or any other pejorative terms. And then the defense has filed a response alleging some behavior. Let's start with Mr. Rosenbaum prior to the incident. Go ahead.
Which party would you like to hear from first, Your Honor?
I don't know, let's see. You're asking me to make a prior determination about what they can and can't say in argument, and we're getting way ahead now. I certainly wouldn't let them, well, I don't want to say that. Am I doing something wrong? Can't do HDMI up there. At the same time, I'm zooming. Can you put the zoom from the TV up there? That is the zoom. Screen share their exhibits.
We could just do the defense experts first, the use of force experts first.
Sure.
Get that, they're all sitting there, get that done, and then move on back to the motions in limine.
Is Dr. Black going to testify, or you mean the state's witness, use of force?
I don't believe Dr. Black is going to testify today.
Well, all right. Any reason we shouldn't just go to Dr. Black right now, or Mr. Willis right now, and we'll take this up later?
That's fine.
Okay. Mr. Willis, you ready for examination?
Yes, I am.
Okay. Would you be kind enough raise your right hand? Do you solemnly swear that the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Go ahead, Mr. Binger.
Could you state your name for the record?
First name is Robert, Robert. Middle initial is C for Charles. Last name is Willis, Willis.
Are you currently employed?
Well, I am self-employed as a consultant. I am retired from previous employment and on a pension.
What was your prior employment?
I've had several. The most recent would be I was an instructor, teacher at Northeast Wisconsin Technical College in Green Bay, primarily in police sciences and the police academy.
Over what period of time did you hold that employment?
Oh, probably from about the year 2002-ish till late 2015. I had also worked there previous as an adjunct instructor. That's a part-time instructor.
When you were an instructor at the Northeast Wisconsin Technical College, what subjects did you instruct on?
A huge variety, actually. I was somewhat their utility man. I taught in the police academy, and my primary responsibility was use of force, defensive tactics, control tactics, pepper spray, taser, baton, those sorts of things, firearms. And I also taught professional communication skills, crisis intervention, taught vehicle contacts, vehicle stops, emergency vehicle operation, and then a host of academic subjects ranging from ethics to constitutional law, to criminal law, juvenile law, how to testify in court, and again, a host of other academic topics. I also taught in-service officers, that would be Brown County, Green Bay, and the surrounding counties, 7 different counties. Their officers would take their yearly in-service training, continued education. I would teach those programs. I then also taught instructor level classes for the state of Wisconsin, and I did that teaching at Northeast Wisconsin Technical College. So those topics I discussed before initially, defensive tactics and so forth, were the instructor level courses that I would teach at that school. I also taught civilians. I taught concealed carry, and I taught security officers, civilian security officers. That just gives you a general sense, I think.
Now, you said that during your time at the Northeast Wisconsin Technical College, you were an instructor at the police academy. Is that right?
Correct. Their police academies. There's 20-some different academies in the state of Wisconsin, but they all teach the same curriculum.
Is it fair to say then that the students that you taught at the police academy were students who were learning how to become police officers?
Correct.
During the time period that you were working at the Northeast Wisconsin Technical College, did you also do consulting work?
I did, yes.
What sort of consulting work did you do?
Well, I did work much similar to what I'm doing here. That would be consulting in civil, criminal cases, disciplinary hearings, administrative hearings, and offering my testimony when it was wished. That would include authoring reports, testifying in court, being involved in depositions and so forth. I also taught for some private companies. When I had any free time, I would teach for a company called Caliber Press, doing a street survival seminar. I only did that a couple of years, and I guess that's over it.
Can you repeat that, please? About street survival?
Oh, okay. Part of my consulting was to teach a course of instruction around the country for a private company called Caliber Press. It was the street survival seminar.
What were the types of subjects that were covered by the street survival seminar?
Pretty much the same topics, except it expanded a bit to how stress affects decisions, especially those in use of force. how physiological, psychological, and emotional decisions are affected by stress. There was a bit of that, not much. And I did infuse my teaching at Northeast Wisconsin Technical College with those topics as well.
During the time period that you were teaching at the Northeast Wisconsin Technical College, did you also serve in law enforcement?
Yes, I did. I was a deputy sheriff, sworn deputy sheriff for Brown County. Although, since I was already getting a salary from Northeast Wisconsin Technical College, I didn't think it ethical to double dip. So I was not taking a salary, and my work was mostly as a consultant and trainer for the Sheriff's Department in Brown County, doing things like doing updates in taser recertifications, in-service classes, helping with some policy decisions, and basically serving at the pleasure of the sheriff. I was not out making arrests nor on patrol.
How long did you serve with the Brown County Sheriff's Department?
I believe records with the state would indicate that till about 2013 or so.
Other than that time that you were with the Brown County Sheriff's Department, do you have any other active law enforcement experience?
Yes, for approximately 10 years, I was a police officer with the city of New Berlin, Wisconsin, which is in the metro area of Milwaukee. It's a suburb of Milwaukee. It's actually in the adjoining county, which is Waukesha County, but it's right on the border. I also did part-time. I did that for 10 years from about 1983 till 92-ish or so. I also did part-time lake patrol work for the town of Merton, and again, continued that into the 2012, 2013 era. But that was very part-time. It was primarily in the summers, and it was patrol on the lakes.
Other than the time that you were an adjunct faculty member and an instructor at the Northeast Wisconsin Technical College, have you spent any other time as a teacher or an instructor?
Oh, yes. I started my teaching even before I was a police officer. I ran a martial arts school. Apparently, word got out that I was reputable and realistic. I gathered a clientele of police officers and came to the attention of Milwaukee Area Technical College and the state of Wisconsin. I then taught not how to be a police officer, because of course I wasn't one at that time, but on how to deal with violent people. And I was asked to become part of back then it was called the RISC program. It's now the DAT, or Defensive and Arrest Tactics program, and to teach that course of instruction at Milwaukee Area Technical College, at Waukesha Area Technical College, and then instructor courses throughout the state, primarily at all the technical colleges, at the Milwaukee Police Department, the Milwaukee Sheriff's Department, the State Patrol Academy, and anywhere that there were people wishing to become instructors in defensive and arrest tactics and those other courses that I've mentioned.
Did you also spend some time working with the Waukesha County Technical College?
Yes, I did. I did so from about 1984. In fact, ironically, I taught my own defensive tactics class when I was a recruit there in 1984, because I had that previous experience and had the, I guess, the okay of MATC that I was doing an okay job. I continued there for, I'd have to check my records, but several years. The entire time I worked for the city of New Berlin, I continued to teach at Waukesha Tech. So well into 1990, 91, someday 92 possibly, I taught part-time while I was a full-time officer at Waukesha Tech and their police academy.
Now, in terms of the instructing and the teaching that you've done in the past, has any of that involved issues of the use of deadly force or self-defense?
Yes, much of it has, yes.
Can you be more specific about how your instructing and teaching has focused on those areas?
Well, after having begun teaching defensive and arrest tactics, in 1986, I was asked by a man named Dennis Hansen of Training and Standards, he was the director of Training and Standards, to do two things. One, to write the Defensive and Arrest Tactics Manual, which included all discussion on use of force and deadly force. One might think a discussion about deadly force might find its way in the firearms manual, but I was told to put it in the Defensive and Arrest Tactics Manual, and that would be the sole source for theory on use of force and use of deadly force. So I did author that document, and the second thing I was asked to do was begin teaching instructor courses that would teach that manual so that it would be the manual taught in all academies. By the late 80s, early 90s, that was accomplished. I continued, again, generally, I always taught defensive and arrest tactics, always taught use of force, always taught the use of deadly force, and of course included that in other venues where it was appropriate, such as if you are going to teach professional communications, that certainly is a very low level of involvement, but it is still, in many views, a use of force. So you would talk about use of force even when speaking about something like professional communication skills, or certainly if you were teaching pepper spray, oleoresin capsicum, or teaching taser, or any of those things, again, the discussions of use of force and use of deadly force would enter in. Certainly in teaching firearms, that would enter in as well.
What is your educational background?
I went to Messmer High School in Milwaukee, Wisconsin. Graduated from there, I believe, in 1967. From 67 to 71, I attended Marquette University and graduated from
Move this along, excuse me. Can we just move the CV into evidence? Otherwise, we're going to be here till 9 o'clock tonight. It's 67 pages.
That's fine.
I'll stipulate, yes, and the CV, and that he is qualified to testify for what the state's calling him. As to the report, we can deal with this at a later time. I'm not looking to delay this. There's certain things in the report that contain evidence that the court has ruled isn't coming in, so I don't want to waive my objection to that.
Is that acceptable?
I'm not sure I understand what's being proposed. If I'm understanding Mr. Richards correctly, there's not going to be a challenge to Mr. Willis's qualifications as an expert on the issue of use of deadly force in self-defense. Is that accurate?
This hearing, correct.
That's fine with me.
Go ahead.
Your Honor, for the record, I will then provide, and I believe these have already been marked and presented to the court. Exhibit 3 is the CV or curriculum vitae prepared by Mr. Willis. My understanding is there's no objection to that, so that'll be introduced for the purposes of this hearing. And then exhibit number 4 is the report that Mr. Willis prepared, and I'll move on to that now. Mr. Willis, do you have your report in front of you?
Yes, sir, I do.
And for the record, that is a document which has a total of 44 pages. Is that correct?
Yes, it is.
On the second page, there is a letter that you wrote me, which is dated October 18th, 2021. Do you see that?
Yes, I do.
Is that the date that you finalized your report in this case?
It was the date I was told to have it finalized, so yes, it was finalized by that date. Perhaps the
and so
then.
So, Mr. Willis, I'll represent to you that Exhibit 4 is the report with that dated letter, which is 44 pages in length. And does that summarize your expert opinion in this case?
As best a report can, yes.
Your Honor, I'd move Exhibit 4 into evidence for the purposes of this hearing.
I have no objection, subject to my earlier objection. Specifically, he refers to some of the events the court has ruled not admissible regarding CVS.
All right. Go ahead.
Your Honor, maybe we can short circuit this a little bit. I understand Mr. Richards essentially conceding that Mr. Willis is qualified. The court will recall my motion was not specifically aimed at the qualifications of Dr. Black. It was more a overall question as to whether or not the jury needs expert testimony to begin with. And I don't have any serious objection to Dr. Black's qualifications in general. So I think we're both on the same page with regard to our experts. I think, like I said, I think the basis for my motion was that I don't think the jury needs this sort of testimony. So if the court is inclined to allow these experts to present their testimony to the jury, then I don't know that there's any further that we need to go today.
Well, I want to understand the scope of your stipulation. Allowing this type of testimony is well, it's a Daubert hearing is what it is, and I did review both of the reports. There was a good deal of material that I'm not going to permit. I know that already without even having a hearing anymore, based upon what I read. And I'm certainly not going, well, I don't want to say that. I almost certainly am not going to permit any opinion from anybody on the ultimate facts in the case. But I will hear you on what aspects you do want, if any, to be permitted from these people. So I guess the defense struck first with Dr. Black's report.
And they had quite a bit of time to cross-examine him, ask him questions, test his opinions.
Yeah.
I think I should get to ask Mr. Willis a few questions.
Well, I agree with that. I will say this. I guess I'm going to ask each of you, you'll be permitted to comment on the other's response. Here's the definition of when I can admit opinion evidence and this type of evidence. Is the testimony about scientific, technical, or other specialized knowledge? Will it assist the trier of fact to understand the evidence or determine a fact and issue? Is the witness qualified as an expert by knowledge, skill, training, or education? Is the testimony based upon sufficient facts or data? Those are the big four, and then is the testimony the product of reliable principles and methods, and has the witness applied the principles and methods reliably to the case, which I think is probably less important. Well, I'll leave that without further statement. And then there are some 5 additional criteria that the Federal Advisory Committee has recommended, but let's just talk about those ones I've already mentioned. Starting with the defense, who brought the first report up. How does Dr. Black's testimony meet it, and why doesn't Mr. Willis's?
Your Honor, if Dr. Black's testimony, as for what we're offering it for, meets it, Mr. Willis's would meet it under the same areas, okay? And what we're talking about specifically, much of with Dr. Black, is his analysis of the situation from a non-law enforcement individual, and his ability to analyze those videotapes frame by frame for the timing. When we have looked at this case, and I've discussed it with numerous people, when one looks at the still pictures, just still photographs, it seems to take forever for the events to unfold. When one looks at the videos, it seems to go snap of an eye. And we tried to break it down for time, so how fast these things are occurring, how fast Kyle Rittenhouse is having to make his decisions, and that goes into the mindset of whether it's reasonable for somebody of his age and stature in that situation. And the information that Dr. Black put forth regarding the first incident at Car Source 3, 63rd and Sheridan, involving Mr. Rosenbaum, is the fact that Kyle was being chased. He tried to avoid Mr. Rosenbaum. He continues on. Turns around, Mr. Rosenbaum is lunging for him, and he's shot 4 times in less than 1 second. Those 4 shots, the 0 shot, and then the last shot was 76 or 77 hundredths, and that's based upon the frames. Then he gets up from there, sees Mr. Rosenbaum, the threats, the mob begins coalescing, saying things, and Kyle heads down Sheridan Road, I always get my directions wrong, in a northerly direction towards the police line, where he's approached by Mr. Grosskreutz, unarmed, and Kyle Rittenhouse does nothing to Mr. Grosskreutz other than have a brief conversation. Hey, did you just shoot that guy, Gaige Grosskreutz asked. Kyle Rittenhouse replies, I'm going to turn myself into the police. I had to. And it's our position, obviously, that he had to shoot, putting forth his self-defense. He heads down the road, and he's attacked by the mob, which is event number 2. From the unidentified person who I've referred to as Jump Kick Man, the first and second shot at him, which are the only 2 shots that miss, to Mr. Grosskreutz is less than 7 seconds total. All those events happened. He's hit in the back of the head. This will be a point of major contention. He's hit in the back of the head with a skateboard and a rock. Mr. Binger says he just fell because he's clumsy, which the evidence will not bear that out. He's on the ground, and he's attacked. There's an individual to, I believe, Kyle's left. There's numerous camera angles at this time, who comes at Kyle. Kyle points his gun his direction, does not fire. That individual backs up. No shot is fired. As that's happening, he's kicked in the face by the man we refer to as Jump Kick Man, and at that point, Mr. Huber goes in for the second whack with the skateboard to Kyle's head and neck. Not his body, his head and his neck. Clearly depicted on the video, still photographs from 2 individuals, Tafin Coxon and Hispanic surname, and the name escapes me right now, but Hernandez, Drew Hernandez. Those photographs are there as Huber comes in, hits him in the head with the skateboard, and grabs for Mr. Rittenhouse gun with his bare hand, pulling on the gun away. That's when the 3rd shot is fired from Kyle Rittenhouse in event number 2. As soon as that happens, Huber falls away. Gaige Grosskreutz runs up to my client with his arm in his right hand, his firearm in his right hand, his phone in his left hand. Both of his hands occupied, unable to grab anything, and Kyle points the firearm at him. This is all on video. As he points the firearm at Gaige Grosskreutz, he stops his advance, puts his hands up like the international I surrender. Something in Mr. Grosskrewitz's mind, I believe, he believes, Mr. Grosskreutz, this will be a point of contention, he thinks Kyle's gun is jammed. As that happens, according to Black's testimony, he backs up, loads his foot, and then lunges towards Kyle, going in a direction closer to him with his right hand arm pointing directly at Kyle's head. Kyle fires 1 shot, hitting Mr. Grosskreutz in the arm. That whole second event, from jump kick to Gaige Grosskreutz, according to the video footage and scoring it by frame, took 7 seconds. All those decisions were made lightning fast by Kyle Rittenhouse. And what was observed by Mr. Black, seeing the individual back away, seeing Kyle point the firearm at Gaige Grosskreutz, he backs away, does not fire. After he shoots Mr. Grosskreutz, an individual with a pipe or a big post and another individual close in on him, he points the firearm at both of them, they back up, showing firearm discipline. They get up, Kyle gets up, they don't get up, they're up. Kyle gets up, rises to his feet, once again begins heading to the police line at 60th and Sheridan Road. As he's heading in that direction, 3 more shots ring out from behind him. Kyle turns around, addresses where he perceives those shots are coming from, does not fire recklessly in that direction, turns around once there's the threat assessed, and heads to the police, puts his hands up at that time, walks up to the police car where he tries to turn himself in, and the member of the Kenosha Police Department tells him to go home. And Mr. Black, one, analyzes the video frame by frame, has that, showing Mr. Huber trying to kneel on Kyle's chest to separate him from his firearm. He has the timing, and he assesses what he perceives as Kyle's perception regarding the individuals who are close to him but not firing, or he doesn't fire at. So it wasn't just anybody gets close to me, I fire. The fact that Gaige Grosskreutz runs up to him while being unarmed, he does not threaten him with a firearm because he perceives no threat to him. Those are the facts that Dr. Black can analyze and say to a jury, this is what I observed about the behavior of the defendant in this situation.
You want to respond to that, Mr.?
Your Honor, I think that's a very powerful closing argument for trial, but I don't think it answered the question that you asked, which is, how does Dr. Black's expertise, training, background assist the jury in making their decision? This is the central question of my motion, Your Honor. The videos can be analyzed in front of the jury, frame by frame. A stopwatch can be used to time the sequence of events for the jury. Arguments can be made as to what that means in terms of thought process, reaction time, stress, decision making, whatever we want to argue. But I didn't hear anything in that narrative that suggests that Dr. Black is necessary to help this jury make this determination. Anyone can use a stopwatch to time a sequence of events in a video. Anyone can stop a video and watch it frame by frame. There are opinions as to the intent of people. I don't think that's something that Dr. Black should be giving an opinion on. I don't think he's qualified to give that opinion. He acknowledges in his report he hasn't spoken to the defendant, so he can't guess what the defendant's intent was. He can't give an opinion as to what the defendant's intent was. He certainly can't give an opinion as to what Joseph Rosenbaum or Anthony Huber intended because they're both dead. So his guess as to their intent is no better than the juror's guess. And his training and expertise is not going to put him in any better position than the reasonable people that we're going to be picking for this jury, who will be shown the exact same things that Dr. Black has seen. They will be able to analyze it and look at it the same way he did, and they can come to their own conclusions. So I think my argument here, Your Honor, is not against one of these experts or for one of these experts in particular. It's that I think this is entirely an issue that the jury is already perfectly well equipped to decide on their own, and I don't think there's anything in Dr. Black's training or expertise that helps them here. This will prolong the trial. There will be 2 experts that will testify probably for several hours. There is a risk of confusion here of some of these issues. There's a risk of impeding the province of the jury by telling them what to decide when it's their decision in the end. It's going to be a very fine line, and the court, I'm sure, will keep a close eye on this in terms of crossing that line into telling the jury what to decide or making their decision for them and invading that province, and that's a delicate balance. But Dr. Black's written opinion here is full of conclusions of people's intent based on what he's seen in a video.
I would tell you now that I would not expect allowing any testimony as to people's intent.
And that's almost the,
Totally conclusory and,
Sure.
and speculative in many respects. We're going to take a 5-minute recess. Yeah. Okay. Twenty-two in the back. There's going to be 22 along the back, 11 in each row, and then there are going to be 6 and 6. So that brings us to 34. And you can correct me if I'm wrong. You each get 6 strikes plus 1 extra because I'm picking multiples, or extras, I should say. So. Your tables will probably be, we're going to move, as they say, the small reporter's table and the other one. And so you might be front and back. We've used it before in civil cases, so let's see. Yeah. I'm sorry, I cut you off.
That's all right, Your Honor. I was focusing on Dr. Black's opinion in this case, and we have his report. And his report is a total of 27 pages, but 29 pages. But the opinion portion of his report really begins on page 19 and continues until page 27. 25. The rest of his report is sort of background and context issues. And when we focus in on the assessment that he's giving us on page 19, for example, he's talking about the timing of these shots, which, as I said earlier, is something that we don't need an expert to help us with. He then talks about the actions of Mr. Rosenbaum and makes an interpretation as to Mr. Rosenbaum's actions and what his intent was, what his emotional feelings were at that point. And again, I don't think that this is something that Dr. Black is qualified to give an opinion on. I don't think that it is something that the jury needs an expert to help them with. Dr. Black's opinion is based on the same video that the jurors will watch.
On page
19 into 20, Your Honor.
Okay.
So on page 19, for example, Dr. Black talks on paragraph 3 at the middle of the page here. He focuses on the incident with Mr. Rosenbaum. At the bottom of that page, he talks about the timing of the shots, which again is something that we can easily do on our own. And then on page 20, he continues and talks about his interpretation of Mr. Rosenbaum's actions. Okay. There's a paragraph there, Roman numeral 2, and he talks about the throwing of a plastic bag, and he concludes that paragraph by saying how it was perceived as unknown at this time. So he's not offering anything of assistance there. And then in the subparagraph A, he characterizes Mr. Rosenbaum as angry, attempting to engage physically, and appears engaged in attempting to take the weapon of Mr. Rittenhouse. Again, we can watch the video. The jury can watch the video. The jury can make its own conclusions as to what Mr. Rosenbaum was doing or wasn't doing or what his intent was. There is nothing in Dr. Black's expertise or training, there's no scientific method here that puts him in a better position to interpret Mr. Rosenbaum's intent than those jurors will be. We don't need his expert opinion on that. He then talks about what that intent means and characterizes it as one in which the defendant needs to protect himself by using deadly force because he's concerned about losing his weapon. Again, as I said earlier, the defendant has given no statement. Dr. Black has no knowledge of what the defendant was really thinking at that time, and I don't think he can give an opinion as to what Mr. Rosenbaum's intent was. He then transitions into the subsequent incidents between the defendant and Mr. Huber, Mr. Grosskreutz, and other individuals, and this is on page 22 of his report. He characterizes the behavior by timing the shots and the movements of various people. Again, this is all things that are self-evident in the video. And then he talks about the defendant, and at the bottom of page 22, he characterizes the crowd as a viable threat. He says that the defendant is in a position of disadvantage. He talks about the defendant being fatigued physically and cognitively. These are things that I don't know how he would be in any better position than the jurors to watch that video and make a conclusion. These are not issues that require any sort of specialized knowledge or training. These are, if you believe what he's saying, they're, I suppose, relatively common sense. But nonetheless, these are things that we don't need any expert to tell us about. On page 23, he talks about Mr. Huber's actions. He characterizes Mr. Huber's movements, the skateboard, putting his knees on the defendant. Again, these are his interpretations of a video that the jury's going to watch. The jury can make their own conclusions as to what Mr. Huber was or was not doing or what he may have intended or did not intend. But the defendant, or Dr. Black, is not in a position to give us an opinion on this. There's a characterization of Mr. Huber attempting to disarm Mr. Rittenhouse. Again, that's a conclusion of Mr. Huber's intent. Dr. Black has no way of knowing that. Mr. Huber's dead now, so no one will know for sure what his intent was. On page 24, he characterizes Mr. Rittenhouse's focus and his state of mind at the time of these incidents. Again, he hasn't spoken to the defendant, and I don't think that there's any training or knowledge that Dr. Black has that can assist this jury any better than anybody who watches these videos. He then talks about the interaction with Mr. Grosskreutz. He characterizes Mr. Grosskreutz's movements, much like Mr. Richards just demonstrated for us. And I submit that what we just saw in terms of Attorney Richards' movements here in the courtroom is something that can be done during the trial. We don't need Dr. Black to show us this. And Attorney Richards has drawn some conclusions as to what those movements mean. The jury will watch the video. They can draw their own conclusions. But I don't think Dr. Black's expert background or training here assists this jury in making any of these determinations. I think the jury should be allowed to watch the videos, hear the arguments of the attorneys, hear the testimony of the witnesses that have factual knowledge about this, and they can reach their own conclusions. Thank you.
Thank you.
Briefly in response, I'm at a loss for words for the state actually saying to the court or anybody that will listen, just use a stopwatch. If we have 5 people timing these things, you're going to have 5 different stopwatches, 5 different times. They're going to be greatly different. Dr. Black is certified in video analysis. He can break it down. He knows how many frames per second each thing has. Counting the frames, he can say exactly how much. I know that the state has sent out the video to an expert, and I suspect that the video expert has said the same thing that Dr. Black has. But we don't know that because there's no report. So that is important, very important. As to statements, Mr. Binger said we don't know anything about what was in Mr. Rosenbaum's mind. We do know what was in Mr. Rosenbaum's mind from his prior behavior directed at Kyle Rittenhouse. It's reported by an independent witness who is on both of our witness lists that Mr. Rosenbaum stated to Kyle and that individual, if I get either of you two alone, I'm going to kill you. That was heard by a witness on the state's list. If they don't call him, we'll be calling him. He was present when Mr. Rosenbaum was threatening other people at Car Source 3, an individual, Ms. Felder, and he said words to the effect that he was going to rip their hearts out. He didn't care and wasn't afraid to go back to jail. Mr. Rosenbaum's words, as reported by independent witnesses. That's something that can be used to assess what was in Mr. Rosenbaum's state of mind as he, in an unprovoked manner, hiding behind cars, came out and chased Kyle Rittenhouse, who was not doing anything illegal. He talks, the other point, prolonging the trial. I'm not worried about the length of the trial. I'm worried about getting it right, Your Honor. And if this takes a little bit of time but aids the jury in their understanding, I think it's important. I don't think Dr. Black and his video breakdown and some of the observations that he saw regarding other individuals that evening and Kyle reacted to those individuals, I think that is important. And the other one that kind of struck me as just crazy was Mr. Binger talking about Mr. Black would testify that Huber was trying to disarm Kyle Rittenhouse. In prior arguments in this court, Mr. Binger has made that argument. He was a hero trying to disarm Kyle Rittenhouse. And that's what Kyle reacted to as the gun was trying to be pulled away from him through videos and still photographs. The timing, as it was said at the beginning of event number 2 to the time he gets to the police, 49 seconds. All of that are things that put the events of August 25th in a very important context, specifically from the legal standpoint. How this 17-year-old individual was making the decisions that evening, whether or not they were reasonable under the circumstances as they existed at that time. And those factors that this self-defense expert and video expert looks at can aid the jury in making their decision. I understand he can't say, this is self-defense, that's it. That's the ultimate issue. But he does have much to say that would be of aid to the 12 people who are ultimately going to decide this case.
All right, now let's talk about Mr. Willis's report. And you want to start with your thoughts on that?
Well, I'd kind of like to be able to ask him some questions. I think that would be helpful, since the state's had, what, an hour or so to ask Mr. Black a bunch of questions?
Just some preliminary thoughts that I had were that Dr. Black's, what I thought, I think I said to you last time that were some things that I learned in reading his report that I had not previously known after trying many, many cases, murder cases, everything else. Auto collisions. The parts that I thought would qualify under Daubert as beyond the knowledge of most lay people were his comments on the timing of the photos, and I do agree with Mr. Richard's observation that you can certainly present competing time measurements if you want, but yeah, and that will be admissible as well from somebody who suggests a strategy by which it was done that sounds reliable, and because time is a critical ingredient in this case. There was a police officer accused of some sort of homicide a few years ago in Milwaukee, and the state, I think, conceded that the first shot was of a fleeing suspect who had a gun, that the first shot was justified, but claimed that the second shot was felonious homicide. And I don't remember what the time span was, but I thought it was less than a second. Maybe it was more than that. But it was a very, very brief period of time. And I remember Jonathan Smith was on the case, and timing was a critical element in that particular case. I don't want to say whether it will or won't be in this case, but I do think timing's critical. And as I say, it's not that I feel that make any judgment as to whether Dr. Black has measured the time correctly, although he's discussed the technique he has used, and you're certainly welcome to offer competing measurement, but I think it will save us a lot of time and increase the possibility of accuracy in this, what may be a very critical examination or critical feature of the examination of these incidents, to know the timing. That's number one. The other thing that struck me about the report, which hasn't been mentioned today, was his example about driving a car and the focus of the average person's attention. And I think I may even have mentioned this. I mentioned it in a case recently, and I thought maybe it was this one, that people are wildly inaccurate about times and distances when they're testifying in court. And auto collisions, where someone says, one motorist will say, I pulled into the intersection and I saw the other car to the left of me, and find it now. I used to keep it in here. How far a car travels at a certain speed, and I thought the number I was thinking was like 157 feet in a second at I don't know how many miles per hour. Maybe one of these guys can help me, but the point is, a witness will say, yeah, Well, from the time I first saw the car until the time it collided with my car, it was 5 seconds. And I think, oh my gosh, this is like 750 feet. And that's more than 2 football fields in length. And so obviously the witness is in error. And what the discussion that went on for a number of pages about what people perceive and how their vision becomes focused at particular moments, without respect to this case or this person, I thought could be of value to the jury, and I think it's of a scientific or technical nature that most folks don't know that. And as I say, I know that most folks don't know it because of the bizarre answers I get here on times and distances. I had a deputy sheriff one time justify that the width of a standard size automobile was 4 feet, and you couldn't shake him from that. He was not going to be shook. And the case was lost because and I know because I was the prosecutor. Well, I shouldn't say why it was lost, but it was lost because I did a bad job. But I could not shake this officer from testifying that this automobile from side to side was 4 feet. And it wasn't. It was a full-size car. So that's the kind of thing that I'm talking about here that I think is specialized knowledge that can be of assistance to the jury. So that's what I saw in Dr. Black's report. I have to tell you, I don't recall seeing any kind of technical information in the report of Mr. Wells, which, by the way, was very comprehensive, and I thought he put a lot of time into it and came up with a lot of descriptive material that was interesting, but which was really something for the lawyers to argue, present evidence and argue, as opposed to something technical or scientific. So and now that's just a preliminary statement. You're welcome to bash away.
Your Honor, I think if the court is suggesting that Dr. Black is going to testify about the timing of the shots and about a person's focus of attention, such as driving, for example, I think those are things that he can testify about. There's a lot more to his report than that.
Oh, there sure is.
So that's what's concerning to me.
Well, I understand.
And Mr. Willis's report, I think, targets a lot of the opinions as to the ultimate question here. Was this a justified shooting? Was self-defense warranted here? And Mr. Willis gives an opinion on that issue. Dr. Black does too. And so I think what I'm hearing the court say is if we limit Dr. Black's testimony to the issues you've identified, then those are technical scientific issues that the jury may benefit from. And of course, parties will argue about it and whatnot. I think if we go further than that into Dr. Black's ultimate opinion and intent of parties and what people were thinking and why they acted a certain way, then Mr. Willis should be allowed to offer his contrary interpretation of those things as well.
If he wants to provide one, I'd love to hear it. It's not in his report.
Well, he gave plenty of opinions. They both did, but
fine, but he didn't.
Mr. Willis more so.
There's nothing regarding timing.
No. I think that the state has indicated that it does not object to Dr. Black testifying on the timing and on the other feature that I mentioned about human behavior, I'll call it, in terms of what people see, what they perceive, and to some degree the assessment.
I'm fine with that, Your Honor.
No other evidence from either of the experts?
Well, if he has something that he wishes to offer from his expert, that's what I'd like to hear.
Well, I know it, and that's what I'm saying. When I read the report, no criticism of the caliber of the report, the thoroughness. Just it essentially there was nothing scientific or technical that I saw, and as a consequence, it's inadmissible. So that was my preliminary impression. So I'm not going to let you ask any questions unless they are going to try to defend it and say, no, he should be allowed to testify.
I just want to clarify, Your Honor, what your specific ruling is with regard to Dr. Black's testimony. As I understand it, issue 1 is the timing of the shots, where he has apparently done some sort of analysis of the videos and will offer an assessment of the sequence of shots and the timing thereof, based on his training as a video analyst. I don't have an objection as long as that's where we stop. But if we start arguing that this means that someone intended to do something, or means, then I think we're crossing the line. But as long as we stop at that point and we just tell the jury these shots are, you know, within this certain time period, I have no objection to that.
And the other one I mentioned was the...
I'll get to that in a second. I just want to,
okay.
I want to take them one at a
Okay.
time if we could, please. Thank you.
Now, what about Mr. Willis? Are you defending any part of the report in terms of
Well,
its presentation under the Daubert rule?
Sure, and I wanted to ask the court's specific ruling on Dr. Black before I answer that question, Your Honor, because I need to know how far the defense is going to be allowed to go with Dr. Black, because then that helps me to decide how I want to approach Mr. Willis. So that's why I'm asking for some clarification, Your Honor. On the first issue of Dr. Black's timing of the shots, if we're going to limit it to he watched the videos, he's got a video analysis background, and he can tell us that the shots are, you know, 0.25 seconds apart or whatever, and that's it on that issue, on that first issue, then I have no objection to that. The second issue, my understanding is the court would welcome his expertise on, you use the example of driving and people's focus of attention, and I assume that that's going to involve, you know, the ability to perceive and accurately describe events when you are very focused on one activity such as driving. And that's an issue of technical and scientific knowledge that I don't have an objection to. But again, I think it's important we draw the line and we don't cross over into that means that Mr. Rittenhouse was thinking this or intending this or couldn't pay attention to this or couldn't understand this event or things like that.
That's for argument for the lawyers.
Okay. So if we're drawing the line where I have just drawn it, then I have no objection to Dr. Black, and I do not intend to introduce testimony from Mr. Willis. But I need to make that clear, and I need to have some understanding with everybody, if I could, with all due respect, Your Honor, because otherwise, if not, then I want to reassess where we're at.
Your Honor, at the risk of talking more, Dr. Black would testify as to the timing of the events of that evening, based upon his videographic review. When Mr. Binger says he'll testify about the shots, no, he'll testify about when he left from the lot or the gas station at
You're talking about timing of events as opposed to timing of shots.
And shots. But
okay.
It's...
You're right, and shots.
Yeah, so it's not just event number 1, 0.76 seconds, broken up X, Y, and Z. Event number 2, broken up this way. It's basically from the time he leaves 60th and Sheridan, gets to 63rd and Sheridan at car source, what I refer to as car source 3, to the time he tries to surrender to the Kenosha Police Department.
So, but otherwise, you're okay with what he said? But that would be the limitation on doctor's testimony?
Yes.
Is that okay with you? And not limited just to shots, but to events?
I understand, and that's fine.
Okay. All right. So, are you offering Dr. Willis, or Mr. Willis, then, for anything?
At this point, Your Honor, no. With the understanding of what the limitations of Dr. Black's testimony are, as we've just put on the record, then no, I am not going to be calling Mr. Willis.
Okay. So, I don't intend to let you ask any questions unless you have some really good reason.
No, based upon the court's ruling, I don't need to. If day 10 of jury trial, Mr. Binger says, I'm calling Mr. Willis.
Oh, my goodness, don't even say such a thing.
Well,
after this, unless they come forward and say, here's why, and then we'll
have to deal with it.
Talk it out.
Okay, sounds good.
Okay. So, all right. Are we then finished with our testimonial portion of our day?
I believe so.
I believe so.
All right, you gentlemen are welcome to remain on or leave, whichever you prefer. I'll leave the Zoom going so you can keep on. Now, we were talking about the motion of the state regarding, let's see, motion eliminate, reference about terminology to be applied, or maybe which the state fears the defense may apply to these folks. I would tell you that I don't think I'm inclined at all towards prior restraint. I would encourage restraint in opening statement, but let the evidence show what the evidence shows, and if the evidence shows that any or more than one of these people were engaging in arson, rioting, or looting, then I'm not going to tell the defense they can't call them that.
I think, Your Honor, if I were to count the number of times that you've admonished me not to call someone a victim during a trial, it would be in the thousands.
You made that point, and this is a long-held opinion of mine, which very few judges, I guess, share with me, and I've talked with others around the state, and they're scratching their heads, why is Schrader doing that? And I think it's the word victim is a loaded word, and I think alleged victim is a cousin to it. Now, I hear very capable, responsible, excellent judges who will be telling a story about a case that's ongoing, and they're not talking out of school. I mean, they're not saying anything that wasn't already publicly exhibited in the court, but they'll talk about the victim. And I think you don't even realize that you're putting a very, very loaded term into the discussion. And I don't like the term alleged victim either. So I do, you're correct, insist upon, in every case, that the term complaining witness be used. Except in the case of this case, and I think I already told you folks, you can refer to the decedent as appropriate. But I don't think that has anything to do with this issue where if there's evidence to support one of the people. Let's give a mythical name to someone who might have been shot in this instance, and we'll talk about Smitty. And I don't think there would be anything inappropriate about you talking to the jury and saying, you know, Smitty was an active churchgoer. He was always at all the festivals, and he helped people out. He'd raise money, and he'd take it down personally and give it to people. And that's all. That's all. You could do that and beatify this person for the jury. He can demonize them if he wants, if he thinks he's going to score points with the jury. What he can't do, one of the people who formerly worked in the district attorney's office, more than once I had to reprove him for telling a jury, calling the defendant a worthless excuse for a human being. That's out of line. But if he thinks that he is using a term that the person has earned by his behavior, I don't think I'm going to, in advance, restrain him from doing that. And it's not, I don't think it has anything to do with the rule that I have that does not permit the use of the word victim until that's been decided.
I respectfully disagree, Your Honor. I think it's the exact same issue. The terms that I'm identifying here, such as rioters, looters, arsonists, are as loaded, if not more loaded, than the term victim, Your Honor. And I've had many trials with you, Your Honor, where there has been evidence that a person has suffered some sort of injury at the hands of the defendant, and you have still not allowed me to call them a victim, even after the evidence has come in, because there's been no jury determination. I don't think
you're accurate about that. I am talking about the use of the term victim in regular discourse, not in final argument when you're arguing that the person was the victim of a crime. I think that
my recollection is different, Your Honor, but I think the overall point the court is concerned about is that we are labeling someone when ultimately it's the jury's call. We are labeling them before the jury makes their decision. And your concern with the term victim, as I understand it, is...
You tell me that if you in final argument said to the jury, Kyle Rittenhouse is a cold-blooded killer, that would be... You don't think that you'd be allowed to do that?
I think I should be. I think I should be allowed to call people a victim, too.
Why can't he call the victim an arsonist if that's what he thinks he can prove?
Your Honor, I have practiced in most of the courts in this county, and other than you, as you rightly pointed out, the other judges do allow us to call people victims, even at the beginning in an opening statement. And I would like to be able to do that in your court, but you've made it clear to me that we can't. And I think your concern there is that it is a loaded term. We are telling the jury something when there's been no judicial determination of that. And I think that's your reason for prohibiting the use of that term. I disagree. I think the state should be allowed to use it. We have a statute called the Victims' Rights Law. We have a constitutional amendment protecting the rights of victims. Our office works very hard to protect the rights of people that are victims of crime. And we have a department called our Victim Witness Coordinator. So we use the term all the time. I use it all the time, and I think it should be used all the time. My point in this motion, Your Honor, is twofold. One is it's a double standard, and you've indicated you don't agree with that. So I'm going to move to my second point, and which is part of another motion in limine here, which is my motion in limine number 3, which is also in dispute. And that is that on this particular evening, we've already heard characterizations of behavior by Mr. Rosenbaum that night, by Mr. Huber that night. I don't know if there's been a lot about Mr. Grosskreutz, but their behavior that night has nothing to do with this case unless it was witnessed by the defendant. This is going to be a case about self-defense. So we're going to talk about the defendant's state of mind. And you said earlier in this hearing, and I agree with you, his state of mind is the most important thing in this case. And if there are things he witnessed with his own eyes by Mr. Huber, Mr. Rosenbaum, Mr. Grosskreutz, I have no problem with that, because it does go to his state of mind. But the defense wants to argue, for example, that Mr. Rosenbaum, we have a well-known video of him at the Ultimate gas station that evening saying certain inflammatory things to other people. There is no evidence that I'm aware of that the defendant witnessed that. He's probably seen the video since, but that particular night, he wasn't there, didn't see it, didn't hear it, didn't know anything about it. So, why would that be relevant? If it is witnessed by the defendant, it goes to his state of mind. If it wasn't, it's another act. It is an other act because the only purpose of introducing it would be either for some legitimate purpose, like knowledge or intent or motive, or to show that Mr. Rosenbaum acted in conformity, that it's his character, which is impermissible. We don't allow that type of character evidence. So, my motion in limine number 3 asks this court to rule that anything that Mr. Rittenhouse didn't personally witness that night on behalf of the 3 individuals that I've named is not admissible. It needs to be the subject of an other acts motion, which none has been filed, and I think that would be denied anyway because I think it's character evidence and it's propensity evidence. It does not go to his state of mind. The defense has earlier argued in this case that Mr. Rosenbaum's state of mind is somehow relevant to the reckless charge here. That is illogical. There is no connection whatsoever. Mr. Rittenhouse may have acted recklessly based on what he observed. He may have not acted recklessly based on what he observed. We've talked earlier about the jury instruction on recklessness. It talks about his circumstances. It talks about his state of mind. It does not talk about things that happened elsewhere that he didn't witness by other people. That cannot be relevant to the reckless charge. And it certainly isn't relevant to self-defense. He can't argue self-defense against things he's not aware of. So these other acts are strictly designed to attack the reputation of these individuals. It's designed to paint them in the worst possible light, to prejudice them. 2 of them can't defend themselves, Mr. Rosenbaum and Mr. Huber, because the defendant killed them. And it's unduly prejudicial to the jury to be told about any of those things, because the risk here, Your Honor, and this goes right back to the motion that we argued with regard to Mr. Rosenbaum, where the defense was seeking to introduce evidence that he was a sex offender. This runs the risk that the jury is going to decide that it's okay to kill Mr. Rosenbaum because he was convicted of a sex offense 15 years ago. Or it's okay to kill Mr. Rosenbaum because earlier that night in a separate location, he might have been involved in some sort of disorderly activity. started a fire, started using racial slurs, challenged people to a fight. None of those things were witnessed by Mr. Rittenhouse. So it has no bearing on his state of mind or his self-defense. So as I said in my motion, Your Honor, and this pertains also to my first motion eliminating when we talk about rioters, looters, or arsonists. The only evidence that the defense can introduce to establish that one of these people might have been a rioter or a looter or an arsonist is evidence that was not witnessed by Mr. Rittenhouse. So again, if he didn't witness it, it should not be admissible.
Thank you. Who's going to talk? Mr.
Judge, do you need me to address number 1 at all on the rioter thing, or are we good on that? Because I'm happy to show you our good faith basis for belief.
No, as I said, if he comes up with the evidence that he thinks supports a finding that the defendant is guilty on the homicide charges, then I'm not going to stop him if he, even over your objection, if he calls him a cold-blooded killer.
Understood.
Even if if he presents evidence from which a jury could find that, then that's a perfectly acceptable argument. And from the defense standpoint, if you present evidence that these people were engaged in lawless behavior or unlawful behavior or violent behavior, then I would let you use descriptive terms in your argument.
Okay, so I'll leave that.
So you don't need to talk about it.
Okay, very good. So dealing with motion in limine number 3, I've kind of plowed this field already. So the idea behind some of these charges deal with all of the facts and circumstances going on that evening. I understand because it doesn't help Mr. Binger when we talk about what happened that entire night. It's the behavior of many people there was lawless. Mr. Rosenbaum is at the top of that list. But all of that lawlessness, all of the facts and circumstances surrounding what is going on is relevant in terms of Kyle Rittenhouse's conduct. I think it's impossible to say that it's not. And for him to limit and say what happened that evening, it's the same course of conduct. That's like me saying what I said to you 10 seconds earlier is other acts, because I'm not saying it right now. It's one course of conduct that happened. Mr. Rosenbaum never left. Mr. Grosskreutz never left. Mr. Huber never left. And Mr. Rittenhouse never left. They're all there the entire night. And this is what's going on. Mr. Rosenbaum is walking around with weapons. He's threatening people. He's threatening to kill people. He's starting fires. He's pushing lit dumpsters toward gas stations. All of that stuff is part and parcel of the facts and circumstances under the totality of the circumstances. It is not, we're not asking that there be McMorris evidence admitted of things that Kyle's aware of that he's done in the past. But to say this whole case comes down to those 3 minutes in a vacuum without taking everything else that is going on it's illogical based on the case. So it's not other acts evidence. It's the course of conduct through the evening. And because he's charged it the way that he's charged it, like the prior ruling on number 5, his state of mind, what is happening, all of those things are relevant. We don't have a peaceful protest. The lead detective in this case called it the most chaotic night he's ever seen. Those kind of things set the stage for these charges and for Mr. Rittenhouse's conduct. It is all relevant as it relates to whether or not his behavior under those circumstances was reckless and or intentional. So it should all be admitted.
There are, and this was discussed by the Supreme Court in the state against Jackson, I think 7 years ago. I think of it here somewhere. 2014, Wisconsin 4. And of course, I always honor the Supreme Court and it's what it's saying, but I had a murder case about 20 years ago. Perhaps you've heard of it. State against Mark Jensen, and I made an evidentiary ruling here, and the DA appealed it, and it went to the Supreme Court, and it's been in going to trial again next April, 20 years later, because the Supreme Court made unanimously reversed my evidentiary decision, and they've been told now that by the federal court that they were wrong in doing that the original ruling was a correct one. And so I say that as a prelude, not that I'm always right, but that I don't want to totally embrace the Supreme Court's discussion in that Jackson case, but it was beautiful in terms of its realization that there are three different rules at work here with this type of evidence, and there is an ancient rule, and I do mean ancient. I was just looking the other day at the Federal Advisory Committee's commentary on it over the years, and they talk about it being an ancient rule, and it's the only reason it was still being used is because it's ancient, but it is our rule, and you can look it up in McCormick 157 or at 155 to 161, 157. Wigmore, well, any evidentiary treatise. And it's codified under the Federal Rule 404, our Rule 904, subsection, I don't, what's our number on it? Well, the federal rule is subsection B, subsection. One, I guess. This is the commentary from the advisory committee. I guess I can't give you a date on it, but it says in most jurisdictions today, the circumstantial use of character is rejected, but with important exceptions. An accused may introduce pertinent evidence of good character. Well, let's skip that one because it's not it here. Subsection 2. An accused may introduce pertinent evidence of the character of the victim, and they do use the word victim, by the way, as in support of a claim of self-defense to a charge of homicide or consent in a case of rape. That's without reference to whether the defendant knew about it. It's not McMorris evidence, as is stated by the defense. This is the Jackson case that I cited, paragraph 48. When the exception has been satisfied, one-way character evidence may be presented in the form of reputation or opinion testimony. When the exception has been satisfied and a defendant seeks to admit specific instances of the victim's prior conduct, however, it must be the case that the character or a trait of character of the victim is an essential element of the charge, claim, or defense. And this is at paragraph 68. On the other hand, the introduction of specific acts to prove character requires a different analysis. Of the three methods of proving character provided by the rule, evidence of specific instances of conduct is the most convincing. At the same time, it possesses the greatest capacity to arouse prejudice, to confuse, to surprise, and to consume time. A court may properly consider the value of the admissibility of specific acts against competing interests, such as prejudice, confusion, or creating a trial within a trial. In other words, does the probative value outweigh the prejudicial effect? The use of character evidence shown through specific acts requires even more than the foundation required for the admission of reputation or opinion testimony. To admit specific acts to show character, the character or trait of character must be an essential element of the charge, claim, or defense. And this is all in the context of a discussion of a defendant who was not aware of the prior allegedly violent conduct of his victim, and was offering well, I won't get into the Supreme Court commented how poorly presented the defense had been, but it says, nevertheless, this is the court at 81, nevertheless, even if character or a trait of character is an essential element, the circuit court is endowed with the authority to exercise its discretion regarding admissibility. So what is the essential element that the defense is trying to prove here? Who was the aggressor? I think on that issue,
I disagree, Your Honor. I think that's part of it, but we have a person armed with an AR-15 shooting an unarmed man.
An unarmed man can't be an aggressor?
I don't think it matters whether he is. I don't think you get to kill somebody with a gun when they're unarmed, even if they're the aggressor. I mean, let's think about a bar fight, Your Honor. We have a lot of bar fights in our community.
Let's not talk about a bar fight. This isn't a bar fight. This was a bar fight that the Supreme Court is talking about.
Sure.
It's not a bar fight.
You've got an armed person shooting an unarmed person, Your Honor.
Right.
That's the question.
Does that mean it shouldn't even go to the jury? I'll just take it away from him and tell him he's guilty?
No, I'm saying that the issue is whether or not deadly force was justified. Was there a risk of great bodily harm or death to the defendant at that time? That's the question.
And one of the factors in that is who is the aggressor?
I think the aggressor issue, it can preclude the defendant from presenting self-defense.
Probably.
But I don't think otherwise it has an impact on it.
It's not a factor to be considered?
Only if it precludes the defendant from presenting self-defense. I don't think it has any other... I don't think it bears on the use of deadly force and whether or not the defendant was at risk of great bodily harm or death. I don't think whether he's the aggressor or the other side is the aggressor changes that equation. The central question is, was he at risk of great bodily harm or death?
That's a jury question. It goes to the reasonableness. I mean, if a jury doesn't think that an armed man with an AR-15 shooting an unarmed man is reasonable, then that's the finding that they make. But to say, I'm not totally following the argument that he's...
Your question is really suggesting to me that the jury cannot acquit the defendant because he had the gun and the other man didn't. Do you think that's consistent with our law?
Your Honor, I'm going to take a look at the jury instructions here on self-defense here. So we have jury instruction 805. Which talks about self-defense. And unless I'm reading it wrong, I don't see anything in that jury instruction about who is the aggressor. It is not an element as to that issue.
Well, here's, this is a dissenting opinion, and this is the late Justice Abramson at paragraph 126, talking about the particular case that was before the court, and says the record demonstrates that the issue of who was, and just a brief synopsis, the defendant shot and killed a man who was unarmed, and it was a post-bar fight, but the defendant wanted to offer evidence of the mean disposition, the violent disposition of the person whom he shot, of which he was not aware. And that was the discussion of the entire case. And this is Chief Justice Abramson, paragraph 126. The record demonstrates that the issue of who was first aggressor was an essential part of the case for both parties during and after the presentation of evidence. You're telling me who's the aggressor in a case where an armed man shoots an unarmed man? That's not an issue. Now, you're right in the sense that it's Justice Abramson was in the dissent, but she certainly made a point there that is at variance with what you're telling me.
Your Honor, I'm reading 805, 810, and 815, which are the three jury instructions that I think are most pertinent to the self-defense issue here. 805 and 810 say nothing about who is the aggressor or who provokes. 815 brings in the issue of provocation, and it applies to the defendant. It talks about the defendant provoking an attack and therefore essentially being prohibited from claiming self-defense. And then it talks about if the defendant provokes an attack and may use proportionate self-defense. The defendant, if he provokes the attack, would initially lose the right to self-defense, but could regain it if he withdraws in good faith and gives adequate notice to the other party. But then it says a person who provokes an attack, whether by lawful or unlawful conduct with intent to use such attack as an excuse to cause death or great bodily harm, is not entitled to a self-defense. As far as I can tell, Your Honor, in terms of the elements of self-defense, the provocation only comes into play in the jury instructions in that narrow scope of whether or not the defendant, if he provoked the attack, therefore would not have the right to claim self-defense. None of these elements or jury instructions talk about whether or not the victim or the decedent here, whether he provokes it or whether that somehow affects the decision of the defendant here. So I disagree with the court that provocation is the key issue in this case. Now, we're going to talk about it. I understand that. There's going to be some evidence about that. The defense is going to argue as to who provoked it, and we're going to respond with an FBI video that shows the defendant chasing down Mr. Rosenbaum and confronting him first. But legally, in terms of the elements here, and again, Jackson stands for whether or not this evidence is relevant to the elements of the crime. I don't see any element here where Mr. Rosenbaum's provocation or being the aggressor changes the jury's decision pursuant to the elements of self-defense.
That makes no sense as it goes to the reasonableness. If I attack you and you use self-defense, the jury gets to hear that because that goes to your the reasonableness of your actions. It doesn't say provocation. It uses it all in terms of the reasonableness of what the defendant believed. And if someone else, if Rosenbaum is the aggressor, it goes directly to the issue of whether or not someone would believe that Mr. Rittenhouse's actions were reasonable. They're not reasonable if if we're having a prayer circle and he walks up and shoots Mr. Rosenbaum, not reasonable. If Mr. Rosenbaum is waiting for him, chases him, after telling him he's going to kill him, that goes to whether or not Mr. Rittenhouse's actions were reasonable. It's that simple. That's it. The aggressor goes to the reasonableness, period.
Anything else?
Your Honor, I think when we look at the Jackson decision, the court is the gatekeeper on evidence. Jackson spends a lot of time talking, as I think the court sort of alluded to, the defense attorney's failure to fully develop this argument at trial. I'm confident the defense in this case will not fall into that same trap. But getting to the issues we started with here, the defense essentially wants to argue that Mr. Rosenbaum earlier in the evening did something that was illegal or bad or wrong or aggressive, and therefore the jury should hear that because that, what exactly? I'm not sure. That makes Mr. Rittenhouse's self-defense more legitimate? No, it doesn't, because Mr. Rittenhouse didn't know about that. It makes Mr. Rittenhouse's intent or recklessness or lack thereof more or less probable? No, it doesn't. He didn't know about it. It didn't happen to him, so it can't affect his state of mind or his actions. It doesn't go to self-defense because he didn't know about it. So I'm left wondering where this comes into play.
The decision was made long ago. So they call it an ancient rule, and some commentators say it wouldn't be a rule if it weren't ancient, but it is a probability rule. What is the probability that someone acts in a threatening and belligerent way would have been threatening and belligerent in this close encounter a while later?
And this is exactly what you said we couldn't introduce when you denied our other acts motions. We argued that Mr. Rittenhouse intervened in a fight with his sister and assaulted a third party. We argued that at the CVS video, he's going to use his gun to shoot shoplifters, and you said that's propensity evidence. You said this is an argument that because he acted away on a certain date, that therefore he acted the exact same way here. And you denied our motions on those issues, or at least closed the door with a very narrow gap. I think you did give us a little bit of leeway depending on the evidence at trial, but you indicated on the record, Your Honor, that was propensity evidence.
I really don't.
I'm sorry?
I don't think they're comparable.
In my opinion, Your Honor, and we'll agree to disagree, it's character, it's propensity evidence. It's saying you did this on this date, so you're going to do the same thing here. That's exactly what 90404 prohibits.
The Jackson case about the history between Mr. McCaleb and Mr. Jackson, and it's nothing like, I mean, these are, they're nothing alike.
I would add, Your Honor,
that the evidence in this case is different. This is within minutes, I assume, minutes. If you come in, I bet you've heard lawyers claim, the Brewers lost tonight, so Schrader's going to be in a bad mood. Now, whether that's true or not, the point is that the people, you can catch somebody on a bad day. We've all seen it. And this is a recognition of this in the rule.
There's another point that I want to make, Your Honor, that is akin to what you had said when you ruled against us on the CVS video and on the fight at the lake. You believed that there was no factual commonality between those prior events and what the defendant did on the night of August 25th. What I'm hearing the defense say is, for example, Mr. Rosenbaum started fires that night. Well, that has nothing to do with the allegation that he chased after Mr. Rittenhouse and tried to physically attack him. Arsonist or alleged arson has nothing to do with an alleged physical assault. There's an argument that Mr. Rosenbaum was shouting racial slurs. That has nothing to do with a physical assault. There's an allegation that he's telling other people at Ultimate Gas Station to shoot him, which clearly is different than what was going on with Mr. Rittenhouse. He clearly didn't want Mr. Rittenhouse to shoot him, so I don't see that there's any commonality there. So this is bad character evidence, Your Honor. This is an attempt to tell the jury Mr. Rosenbaum's a bad guy and deserved to die. That's really what it is. He was an arsonist, he was a rioter, he was starting fights, or not starting fights, he was starting problems, he was disorderly, he was loud, he was whatever. Therefore, it was okay for the defendant to kill him. That's really what's going on here, Your Honor. And that's not at all what 90404 allows. And if there were any evidence in this case, and I would love to hear it, because I haven't seen it, if there was any evidence in this case that Mr. Rosenbaum physically attacked anyone else that night, chased anyone else that night, assaulted anyone else that night, threatened anybody with a weapon that night, we can talk about that. But I don't hear any evidence to that effect. All we're talking about is arson. We're talking about being loud and disorderly. We're talking about, being...
I can't believe some of the things you're saying.
Alleged
all
to be a
we're
rioter.
talking about is arson. Come on.
Arson to a dumpster, Your Honor? Yes.
Arson pushing towards a gas station, they claim.
Yeah,
and whether it's or not,
he didn't push it towards the gas station. He pushed it in the middle of the road to block.
This idea, there's a zone where it's okay that it's unsafe south of Sheridan Road because the police are only going, or 60th Street, because the police are only going to that far south. So I guess everybody lives at his risk. Past that, I don't know what you're saying.
That's not what I said, Your Honor. And Mr. Rosenbaum did not push the dumpster towards a gas station. He, along with a number of other people, were allegedly putting things in the road to block the police Bearcats. That's what was going on.
Okay, all right. Let's talk it. Let's say that's what it is. Mm-hmm. And
that has nothing to do with what he was alleged to have done to Mr. Rittenhouse. Has nothing to do with it. They have nothing in common.
All right. Do we need any more discussion on this?
No, we don't.
All right. So what's the next issue?
I believe we are on
civil lawsuits?
Yes, motion number 4, which has to do with the pending or proposed civil claims on behalf of the families and Mr. Grosskreutz. I'm not familiar with exactly what's going on out there. I've read some news articles about attorneys for these individuals filing claims against the city, the police. I don't know if Mr. Rittenhouse is a party to any of that. I don't really care, frankly. But the defense wants to introduce that evidence, I assume, based on their response, because it goes to bias. These are things that occurred after August 25th.
I have to tell you, this is classic bias evidence. I mean, this is classic bias evidence. The fact that that Mr. Grosskreutz, as an example, has a claim pending against the city or the county or both or neither, whatever, arising out of claims that he makes in terms of incident in which he was injured, that he's got a civil case pending, that's classic bias evidence. There was just a decision came down, I read about the other day from, I think, the Court of Appeals, one of the federal courts of appeals about this classic bias evidence.
So if he testifies, you're saying this will be evidence that can be used to attack him in terms of bias, impeach his credibility?
I would say yes. Okay.
Mr. Rosenbaum and Mr. Huber are not going to testify. So there's no issue of bias.
Do you have another point that you want to make?
I'm sorry?
Go on to your next point.
Well, my motion pertains to those witnesses as well. I understand the court's ruling as Mr. Grosskreutz, if he testifies. If the defense is intending to introduce any evidence as to civil claims that have been filed on behalf of the families of Mr. Rosenbaum and Mr. Huber, that can't go to bias because they're not witnesses.
Did you want to comment on that?
If they call, I guess I don't have a strong opinion on it. I don't think anybody's going to testify from those families. I don't know.
Yeah. It's admissible as bias evidence because it can affect the veracity of the witness's statement. The witness has an economic interest in the outcome of this proceeding. And,
if they're a party to that lawsuit.
And so, obviously, Mr. Grosskreutz is in a different situation. And he correctly points out, if Mr. Huber's father, for example, were to testify in the case with some factual information, which I have heard nothing to suggest that's going to happen, then he would be subject to examination for bias as well. So yes, if he filed a suit, it could be brought up. But other than that, no, they can't bring this in and show, well, these people who were killed must be biased because their survivors filed a lawsuit. That doesn't, it's allowed only because it bears on the credibility of a specific witness.
Your Honor, we've dealt with number 5. There is a final motion in limine that was not responded to by the defense. That's number 6. That all parties refer to the defendant, the deceased, and witnesses formally by their last names, such as Mr. Rittenhouse or Mr. Rosenbaum. Obviously, we can refer to Mr. Rittenhouse as the defendant as well. I'm concerned, Your Honor, because during these motion hearings, oftentimes the defendant is being referred to by his first name, Kyle, and I don't think that's appropriate.
And I will tell you that the standard rule in here, and has been for probably since 1983, is that anyone who is of age will be addressed as Mr., because I don't like it when the bank president gets called Mr. and then some other guy gets called Joe. So they all get called Mr. or Ms. or Doctor or Lieutenant. In a formal mode of address, I can't tell you how many times during a year I tell the witnesses that they have to use, or the attorneys to use formal language. The only exception that I make is that the defense attorney is permitted to call his or her client by a first name, and I've always employed that, and I don't see any reason to change it in this case.
Understood?
Now, you can't, but that's the way the rule that I operate with is that it's his client, because people don't expect that kind of formality between the client and the attorney, whereas other than that, everybody has to use formal mode of address.
Your Honor, I think that takes care of all of my motions in limine. I think we've taken care of the Daubert issue. I don't know if there are any other pending motions to address at this moment.
More of a question.
Sir.
We had some discussions regarding the jury selection. I know you wrote a memo. I've read it. When are we going to get the jurors' names?
Actually, I got a note from the clerk of courts this very day saying neither side has asked for the jury list.
I'm asking.
So I assume that her sending that suggests to me that
Ready.
that it's there.
Okay.
Okay. All right. Anything else today other than that we have a little discussion between ourselves about some management issues?
Nothing else, Your Honor.
All right.
The information.
Judge, can I ask one thing?
Sir.
I had filed I don't need it heard today. I had filed a motion for reconsideration with the legislature.
I did not see that.
Okay, but it's fine. Okay,
It came in today? Okay.
So,
Yeah.
just so it's out there, I'm not expecting anybody to argue it today. I just wanted to let you know that had come in along with.
I will look at it before Monday.
Very good.
And if you want to file something, and you're not required to, you're welcome to do so. Anything else?
The only other thing, Judge, is Attorney Richards made a suggestion to renumber the information so it would go chronologically.
Right.
I did file amended information in that regard. Assuming the defense has no objection, I'd ask that it be accepted.
No objection, obviously. We asked for it. I just think
Okay,
it makes
great.
more sense.
That'll be, and the pleas are the same?
Yes.
Okay. I don't think that's necessary, but just to be sure.
I already did.
I think I saw it already, yeah. And for your information, the jurors will be given numbers, special numbers, 1 through 150, I guess. And there are, in your suggestion, we will address them as juror number blank.
Thank you.
Okay. All right. Thank you. And we'll start again in 5 minutes for our private discussion. Thank you.
Yeah, that'd be great.
Could we get one too, please? Yeah, okay.
You guys stick around? Is that okay? Yeah, probably half an hour. Sure. Okay. This Wednesday? Yeah, that's fine. Fine. Yeah, we're all done. Oh, okay.